A will must comply with certain execution formalities to be valid. For example, a will must generally be signed by the testator and a specific number of witnesses. If a will fails to comply, it's defective and lacks dispositive effect. In Estate of Norton, we explore whether incorporation by reference can render a defective will valid. When Lawrence Norton died, his son, Teab Norton, presented an 8-page document for probate. The first 6 pages were titled as Lawrence's will, but the undated document cut off mid-sentence at the bottom of page 6, suggesting it was incomplete. Each typed page was signed by Lawrence, but there was no witness signatures, meaning the document failed to comply with North Carolina's execution formalities. The remaining 2 pages were titled a codicil to Lawrence's will. The codicil, which was dated 1984, complied with the state's execution formalities. It was stapled to the other 6 pages, and the combined document was found in Lawrence's safe deposit box, in an envelope labeled as the will and codicil to the will of Lawrence Norton. In presenting the document for probate, Teab argued that the validly executed codicil incorporated the will by reference, rendering the will valid. But others opposing the will argued that it wasn't properly incorporated by reference, because the codicil didn't sufficiently identify which will it referred to. At trial, Lawrence's granddaughter testified that Lawrence had her staple the codicil to the presented will shortly after the codicil's execution. A legal secretary testified that she typed the presented will between 1970 and 1977, but she typed multiple wills for Lawrence during that period and wasn't sure when this one was prepared in relation to the others. Additionally, a court clerk testified that Lawrence's safe deposit box contained another codicil executed years earlier. Although the jury held in Teab's favor, the trial judge entered judgment notwithstanding the verdict, holding that the codicil didn't incorporate the will by reference. The state appeals court affirmed, and Teab appealed to the North Carolina Supreme Court.